Next matter before the court is U.S. Bank versus Kathleen Beach.
Just your might not type.
I think he's out there.
Thank you. Good morning. Good morning. As you both know, each party will have 15 minutes to present oral argument. The appellant will proceed first. May reserve up to 5 minutes for rebuttal. We have read the briefs, and so we're ready when you are.
So we don't have to argue them?
Pardon me?
We don't have to argue.
You don't have to,
I'll sit down.
but we're here.
All right. My name is David Patterson. I represent the appellant in this case, and I would like to go with 12 and 3.
Yes.
3 minutes for 12. In this particular case is a foreclosure case, which you're well aware of, and we had 3 assignments of error. The first one was that we believe that the summary judgment shouldn't have been granted, and as we said, we should have heard the whole entire evidence in the case. The second part was where we said that there wasn't any genuine issues and material facts, and therefore it should have been granted summary judgment. And kind of the third one was where we felt that we had a counterclaim, and the counterclaim was denied without any proceedings, any trial, any work at all. And if you notice that the plaintiff in this particular case, the appellee, first there was a motion for summary judgment that was denied because there wasn't leave of court. Then the second one was granted, and that was on a proposed judgment entry from the plaintiff setting forth everything that they wanted was in the judgment entry, and the judge signed it within a few days thereafter and granted summary judgment. We didn't have an opportunity to, number one, to, I want to say, disclaim any of that part, and number two, that we didn't have any part as far as the affidavits and things of the people who submitted evidence saying this is what the actual evidence was, when in fact, as we said in there in our brief, wasn't actually what transpired. And then finally, we should have been given an opportunity in that particular judgment entry to do something about our counterclaim, which we set forth in our original complaint, but that was kind of scooped right over, and we moved on saying that you lost everything. It was kind of interesting to note that the first time the motion for summary judgment was denied, but the second time the identical motion was granted, and then as a result of that, it's kind of unusual, kind of different, but our argument was that this wasn't right. The court should have at least given us an opportunity to argue the facts of this particular case, and at least give us an argument to present our counterclaim. Now, up to this point, nobody had done much of anything except their motion for summary judgment. We hadn't got down to pretrial, we hadn't got down to the actual trial, and we hadn't got down to presenting evidence before the court. And we felt that as a result of that, we didn't get a chance to even show them anything that we had, anything whatsoever. So
Well, you did file a response to the motion for summary judgment on each.
we did the first time, and unfortunately, we didn't. We believed that that was going to be use the same one for the same argument because it was our same argument. And you're right, you're right. You're absolutely right. We didn't do that, but we felt that the argument, and that's a good argument, because we felt it was the same one that was in the first motion, and we thought once again, the court, you can't think ahead, but the court had our brief and had their brief and decided. And unfortunately, what I don't really like is we should have an opportunity, or the judge should have a little time on his hands and should have been able to make his own judgment entry. The judgment entry in this particular case, if you look at it, was identical to the one that was submitted for the judge to sign that the plaintiff had prepared. And as a result, that we lost everything. I mean, we didn't get a chance to do anything. I think we would have had an opportunity to present some of our case and show the court where we believed that there was some holes in their particular case. In the first part of it, as we put in our brief, we believe that there wasn't really a showing that we were in default. I mean, you've got to show that there's a certain amount of money that's still due and owing, and in this particular case, it kind of skipped right over that and moved on to other areas. And it on that alone, I think that the court should, we hope that the court would reverse what took place already. We also said that the person doing the authorized to do the affidavit and say what she did in this particular case was not somebody that was working for the plaintiff. It was somebody that had been working for Wells Fargo and actually was not a party to this part of the action because Wells Fargo was no longer into the case. The case was, as you know, is brought under the caption of U.S. Bank against Kathleen Beach. But also we saw that there was times that we showed in there, and I think and we believe that what transpired was the lady that prepared and signed the affidavit was one, as I indicated a few minutes ago. Her name was Alicia Dope, D-O-E-P-P, and she was the authorized agent of Wells Fargo, but not the plaintiff, as we argued on page 9 of our arguments. And she worked only for one person. That's Wells Fargo, and she's known as a robo-signer, so she sits in a room and does all the signings. But I don't think that that's right, that the court should take her affidavit and not look at really where it came from, and that she really wasn't working for them, and then this affidavit we said was just not the right one. She really didn't have personal knowledge of what was happening. All she had was what she was told and what she was told to sign and how she was told to sign. And based upon that, we said she just wasn't the authorized, not the proper foundation under Rule 56, and therefore the court just on that alone should have denied it. Going on a little bit farther into the case, we believe that the appellee failed to show that in fact it was the legal and proper holder of the note. Now, if you go back in time a little bit, the person, the company that started the action in this particular case was a one that became, later it was defunct and there was some criminal action brought, but that was the one that had the note. That company went bankrupt under Chapter 11, and then afterwards, the conduit company, then afterwards it was bought up by somebody else, and even in their arguments, the plaintiff, even in their arguments said, we lost the note, we do not know where the note is, and as a result of that, we are going to use a duplicate wherever we found the duplicate, because that company's out of business. The company, they just scattered, and some of them were indicted, in fact, in the beginning, but nobody knows where that original note is from the non-party. That was American Brokers Conduit, which actually was the company that transferred to the plaintiff by way of the alleged allonge. And so based upon that, I think that the Thompson case, which we said at the top of page 12, pretty well puts it that the other states and the government said that the person who demands payment and negotiable note must be the duly qualified holder. I don't think in this particular case it was a duly qualified holder. And then further, in the Schwarzwald case, once again, and I bring that up only for the fact that they tightened the ropes and what we have to do, and in court held that when a party lacks the holding in the action, then they can't go ahead and proceed forward with the foreclosure. And I don't think that in this particular case that the plaintiff, U.S. Bank, had the actual note, well, we already said that, but had the assignments that were necessary, therefore shouldn't go forward with the foreclosure. We set forth also that there were several mortgage, or just in Ohio, it holds that the standing interest must be subject to the matter of jurisdiction. Once again, this promissory note was a negotiable instrument, fairly transferable, but we don't believe that it was used here to bring, because the mortgage and the note were separated somewhere along the line, and as a result of it, I don't think they could bring it and get, especially the summary judgment. And our, should be sure to cover, there was a allonge that was attached to it, and once again, there was no evidence to that fact, but we think that there was a prior foreclosure proceedings, and somewhere along the line, that once again, that allonge got separated from the note. In our assignment number 2, we said once again that the same thing that we did before, the summary judgment should have been granted, but I don't think they provided sufficient evidence to grant the summary judgment at that time, and we set that forth in page 18, and that the appellee didn't provide sufficient substantial evidence to support the motion regarding the money owed. As I said earlier, it wasn't actually showing it how much money was owed, what was paid, and what was done as far as the company is concerned. But there also, the compensatory damages that we were allegedly didn't pay, those, once again, they weren't the correct ones, and they weren't satisfied as far as the court is concerned, and I don't think they should have granted the summary judgment at that point. But going on to the third argument, that's the one that I just don't know how a court could grant summary judgment on a counterclaim when they heard no evidence, when they didn't see any evidence, and wasn't submitted any as far as the hearing is concerned. And based upon that, we believe that we should have been given an opportunity to present that evidence. The one, the FDCPA, the Federal Fair Debt Collection Practice, certainly says that you got to bring the debts forward, and we certainly have a right to do that. And I think it goes on to say even more that the holder of the note, therefore creditor, they argue that they say they claim they're a holder, and that the note, therefore, creditor, not a debt collector. They are a debt collector. If you pick up the telephone and call any foreclosure company or any attorney's office dealing with foreclosure, they say we are a debt collector, and so we believe that should have been included in there, and we should have been granted the summary judgment should not have been granted against us. We also said under that, under the FDCPA, it prohibits abusive of false and misleading debt collection and practices. In this case, I think there's false information. Number one, didn't have the note. Number two, we don't know exactly where the note ended up. And number three, the company that originally handled was the original lending, of course, went out of business, and we don't know what happened thereafter. And there was no evidence showing that this is what the chain of events that took place to that company. So all these things put together, we believe we should have had an opportunity to present our counterclaims. We should have been able to, under the Ohio Consumer Sales Practice Act, and do those things of that nature, the fraud involved here, and then the breach of contract. We believe that the court should not have, at this point, granted summary judgment. Thank you.
Thank you.
May it please the court, my name is Scott King. I represent U.S. Bank. U.S. Bank asked the court to affirm. This is an appeal from a foreclosure action which the trial court granted summary judgment, and where the borrower submitted no evidence of any kind whatsoever. I'm going to address three issues, Your Honor. Was there standing in this case? Was there evidence sufficient to support the entry of judgment? And did the trial court correctly dismiss the counterclaims? And I'll address them in that order unless the court has a different preference. Standing is the first one. Your Honor, standing is a question of whether a plaintiff has an interest sufficient to open the courthouse doors. Standing is not winning. I don't need to show that I'm going to win. I just need to show that I have enough interest in the dispute to find out whether I get to win. Under the Schwartzwald case, standing can be shown by either an interest in the note or an interest in the mortgage. U.S. Bank had both. U.S. Bank had an interest in the mortgage. It was the mortgagee of record at the time this case was filed. As the mortgagee of record, that fact by itself gave U.S. Bank the right to open the courthouse doors to see whether or not it was entitled to foreclose. U.S. Bank also had an interest in the note. The evidence before the court was that this loan was originated in 2007. U.S. Bank was assigned the note in 2007. In 2009, there was a forbearance agreement that was executed. In 2011, there was an allonge that was executed that completed endorsements to U.S. Bank. In 2012, there was a trial mortgage plan that was presented, and then there was evidence that in 2013, U.S. Bank as custodian had possession of the note. Any of those facts are sufficient to open the courthouse doors. Any of those facts are sufficient to show that U.S. Bank had standing. And I'm going to leave the standing issue and go to enforceability. Enforceability is a separate question than standing. Standing refers to the ability to open the courthouse doors. Enforceability refers to the right to walk out of the courthouse with a judgment. The standards for showing enforceability are higher and different. Standing requires an interest. Enforceability requires showing you actually have the rights to enforce at the time of judgment. In this case, there was a note in the mortgage. To have the ability to enforce a note, you look to 1303.31. That statute defines persons entitled to enforce PETES as typically being a holder or a person in possession with the rights of the holder. In this case, U.S. Bank qualified as a holder. U.S. Bank had possession of the note at the time through its servicer, Wells Fargo, and the note had been endorsed in blank originally by American Brokers Conduit, the original creditor. Special endorsement had been converted to a special endorsement, I'm sorry, I misspoke. The blank endorsement had been converted to a special endorsement, and the special endorsement had been transferred to U.S. Bank via an allonge. The allonge specifically stated that it was affixed to the note. There was an affidavit that said that the wet ink copy of the note was attached. Those are sufficient to show that U.S. Bank was a holder. Now,
One of your opposing counsel's comments that the note was lost or the allonge was separated from the note.
Neither one of those facts have any basis in the record, Your Honor. This is not a case where there was a lost note affidavit. This is not a case where there was any evidence that the allonge was ever apart from the note. I'm not sure where that came from. That's simply not in the record. In this case, the record was that U.S. Bank had possession of the wet ink copy of the note and that the note had been endorsed appropriately to U.S. Bank. In the brief, there was a reference to securitization. The trust was a securitized trust. Securitization is irrelevant to the issue of enforceability. The code makes clear that to be a person entitled to enforce a note, you need to be a holder or a person in possession with the rights of a holder. The fact that ownership interests in the trust have been securitized have nothing to do with enforcement. There was also a comment that the affiant was from Wells Fargo. It's absolutely correct. Wells Fargo was the servicer identified in the public records for the trust and an agent of the trust. There were business records attached to the affidavit verifying the statements that were made in the affidavit. There is nothing wrong with the affidavit. There was a comment made that there was insufficient evidence of payments. There was a payment history attached to the affidavit. The borrower submitted nothing, zero, zip, in response to any of this. There were no contrary affidavits or evidence of any kind. The trial court correctly held that U.S. Bank was entitled to enforce the note. I'm going to flip over the mortgage now. The trial court also correctly foreclosed on the mortgage. Again, U.S. Bank was the mortgagee of record that presumptively gave it the right to enforce the mortgage. In any event, U.S. Bank was the holder of the note, and as the holder of the note, it had the right to enforce the collateral and its rights against the collateral, which secured payment of the note. So as both the holder and the named mortgagee, U.S. Bank had the right to enforce the note. There was a reference in the brief that the assignment of mortgage postdated the closing date of the trust. The assignment of mortgage was dated in 2011, 2 years before the complaint was filed. That fact is irrelevant. There was evidence the loan was assigned in 2007, prior to the closing date of the trust. In any event, Ms. Beach is not a party to the trust and has no rights to complain about any supposed noncompliance with its provisions. The trial court correctly entered judgment both on the note and the mortgage. I'm going to flip over the counterclaim. Third issue, did the trial court correctly enter summary judgment in favor of U.S. Bank on the counterclaim? It did. I'm going to address the counts in the counterclaim individually. First count is the Fair Debt Collection Practices Act, the FDCPA. To be liable under the FDCPA, you must be a debt collector. A debt collector is defined as being a person who is engaged in the principal business of collecting debts of others. There was no evidence of any kind that U.S. Bank was collecting debts on behalf of anyone else other than itself. The second reason that the FDCPA doesn't apply is that the evidence showed that U.S. Bank was a creditor. Under the FDCPA, creditors and debt collectors are mutually exclusive. If you're one, you can't be the other. In order to be a creditor, you have to have the right to enforce the obligation, which U.S. Bank did, and you had to acquire that right at a time when the loan was not in default. U.S. Bank acquired this loan at a time when it was not in default, way back in 2007. The FDCPA did not apply. In any event, there was no substantive violation of the FDCPA. The only violation claimed was that U.S. Bank did not have standing when it filed the action, but it did have standing. The FDCPA claim was appropriately dismissed. Now, Mr. Patterson said that it wasn't fair for it to be dismissed, he should have had discovery. Your Honor, this case was filed in December of 2013. The motion for summary judgment was not filed until May of 2015. The court didn't enter judgment until July of 2015. Never in that more than a year and a half period, not once was there a request for a continuance for discovery, not once was there a Rule 56F request filed. There was no reason to delay the entry of summary judgment. Next claim was the Consumer Sales Practices Act claim, the CSPA. That claim failed as a matter of law because, number one, U.S. Bank is a financial institution. 134502 specifically, 134501 specifically excludes financial institutions from its definition of a consumer transaction. Number two, for a consumer transaction to exist, there had to be the provision of goods or services. There was neither, just merely the lending of money. And number three, once again, there was no substantive violation. The only violation was that U.S. Bank supposedly commenced the action without standing, and that simply wasn't the case. Another counterclaim was breach of contract, but there was no evidence to support a breach of contract. The only contracts at issue were the note and mortgage. There's no evidence to show that U.S. Bank had done anything to breach either one of them. In any event, Ms. Beach herself breached the note and mortgage by failing to make payments, and that breach precludes any affirmative recovery. Another counterclaim was fraud, but the fraud claim didn't identify any false statements of fact, much less any fact showing scienter, much less any detrimental reliance, much less any damages. There was no evidence to support fraud. The last claim was unjust enrichment. The theory of the unjust enrichment claim was U.S. Bank had been unjustly enriched because it had received payments. That failed for two reasons. Number one, we had the note mortgage. Note mortgage are written contracts, and you can't have an unjust enrichment claim covering the same transaction that are governed by written contracts. And number two, in any event, the evidence affirmatively was that all the payments had been applied to the balance due on the note. The unjust enrichment claim failed as a matter of law. Your Honors, all things, including litigation, must come to an end. Payments on this note are due for 2011. It's almost 5 years. At this point, there was no basis to delay summary judgment. There was no request for a continuance, no contrary evidence below. For all these reasons, U.S. Bank requests the court to affirm. And with that, I'm going to conclude unless the court has any questions.
Apparently not.
Thank you.
In rebuttal, I would say under our assignment of error number 3, we set forth the different items, and we set forth why we believe that they were incorrect, as Mr. King has stated. But the purpose is to eliminate abusive debt collection practices of debt creditors and to ensure debt collectors to refrain from abusive debt collection work. In this particular case, U.S. Bank was doing debt collecting work. They were, in fact, trying to collect on the money. They were, in fact, we claim that they were debt creditor, a debt collector, and as a result, they claim he's a debt collector. We think that, in fact, since they were a holder of the note and therefore were actually a creditor, that they should be under the claim that, in fact, they should be just like anybody else, a debt collector. And as
Would that apply to the servicer of any mortgage?
Yes, it does. Yes, you're right. It does. Yes. And I'm just saying that if you go on a little bit farther, it says the applicant claims it was the holder of the note and therefore a creditor and not a debt collector. I'm saying that they're actually a debt collector, and as you said, there really, in fact, is a situation where we believe that they were under the federal debt collection coverage. They should have been included in, and therefore shouldn't have granted a summary judgment. But there was some time in there, when in these foreclosures, it takes some time, and over a period of time, there was nothing happening as far as the case was concerned, but it was being set for pre-trial, then trial thereafter, and before that happened is when the summary judgment was granted in this case. So, in fact, there was time, and there's no doubt about that, there was time to do these, but we never got to a point where it was actually set down.
Well, that was a situation that could have been under your client's control. If
Yes.
they wanted to take depositions or submit interrogatories or request production of documents.
That's correct, you're absolutely. And we felt that the U.S. Bank was a holder, and in fact, it was endorsed in blank, and we all admit that. We once again say that the note itself was lost, and I guess as a result of that, we should have had an opportunity in which to present that. Actually, the facts is they stipulated, or they set forth, the U.S. Bank did, that they did not have the note, and it was not available. Although they claim that the payment history was what it was, there was at times, and once again, it wasn't real clear, and as a result of that, it probably should have been clear as far as how much was paid and how much was not paid, and that's one of the parts that we said. But we also said that in our three areas in which we had counterclaims, and I think the court should at least give us an opportunity, or should have given us an opportunity to go forward with those. And one of them was the federal debt practice, and one was the fraud, one was the unjust enrichment, and the bank certainly got the house in the end, and for unjust enrichment, they got the house, they got to keep the house, or that's what they're trying to do at the present time. And the fraud was the fact that there was, our claim was, it said that there was a representation and disclosed the concealment fact. We said there was also a transaction on hand that was being falsely, and that was the lady that worked for Wells Fargo. And then finally, we believe that the fact that we should have been able to show this and show that there was, in fact, misgivings all the way along. The unjust enrichment, as I said earlier, was the fact that the U.S. Bank got to keep the house, or keep the house. Thank you very much.
Thank you both for your presentations. The court will take the matter under advisement, will issue a opinion, which will be sent to both parties and also posted on the application. Thank you, gentlemen. Have a good one.
Thank you.